as of Friday, and it just got entered this morning. I saw on the docket asking the court to vacate that order because the due process in several instances in my case were not followed. So I have yet to hear
We'll
hear
be
a
anxious to
response on
hear
that.
how that goes.
Yeah,
Thank you for coming.
yeah, no problem.
Thank you. Any other questions? Senator Erickson.
I keep sitting
Thank you,
down.
Madam Chair. Thank you for being here.
Yes.
Just a quick question. You said it's costing you $1,000 a month for visitation?
Yeah.
Why?
So a lot of the times the recommended provider charges almost double of what other court supervisors charge, but unfortunately this is the provider that courts are recommending, and most of the time my ex-husband's attorney actually, I tried to use other supervisors that were more cost efficient, but my ex-husband's attorney filed a motion to enforce me having to use this particular provider that's $70 an hour per supervised visit with a minimum of 2 hours. So I was calculating it last night, and 6 hours of parenting time per week to see my children would be over like $1,600 a month.
Yep. Sounds
Is
about
there
right.
any way to recoup any of that cost?
Nope.
No, I'm responsible for all the costs.
Thank you. Thank you, Madam Chair.
Senator Falscudo online.
Thank you, Madam Chair. This particular situation has come up. I've been contacted by a constituent, and if somebody in the room could answer this question or clarify. So what my understanding is that if you are dealing with a divorce case and you've got 50-50 shared parenting, that the courts for divorce and children issues, they do pay for that supervised visitation, but you don't pay that if your children were removed for abuse and neglect and they are in state custody. So I think we really need to get a better understanding and make that a distinction on this particular issue. So I don't know if anybody can address that or not, but I think it might be helpful. Thank you so much, Madam Chair.
So just to clarify, this is not a DCF custody issue. This is a
Family.
divorce custody issue.
Correct, yes.
Go Taylor.
And these stories have been coming up. It's really not the purview of this committee to cover family courts, but Representative Humphreys is chair of judiciary, and she actually had a hearing on that very thing this session. So do you want to say something, Representative Humphreys?
Oh, just said we had an informational hearing in March on child custody and child support, and it was heartbreaking, the stories that we heard. So the informational hearing, it doesn't result in any necessarily any legislation, but it gave the committee a good taste of what a lot of us are hearing on this committee. So the Judiciary Committee, separate purview. And so, we will certainly be considering it as far as what we can do as legislation. But hopefully others can advocate for you and others like you. So
Thank you, I appreciate
welcome.
that.
Thank you for
Thank you,
being.
Madam Chair.
Go ahead, Senator Falscudo.
Well, I was just saying thank you. That answered my question. Thank you.
Okay, thank you very much for being here. So next up, we have Peter and Kimberly Berzak, private citizens. Welcome back to committee.
Good morning, ladies and gentlemen of the committee. Memories, not days or years or how children remember time. 3 siblings, Emma, Cora, and Rosa. 0 notifications. 0 allotment for parenting time. 4 birthdays, 3 Christmases, 3 Easters, 1 family cruise, 1 trip to Yellowstone, many, many camping trips. 3 sets of first steps, first words. These are how Anna and Jamie count the time stolen from them by Judge Nicholas St. Peter, Cali County Courts, and TFI service caseworker Sherry Wampler. Senator Godot and Representative Howerton always ask what resolution looks like. But how do you explain to a 4-year-old and a 7-year-old what resolution is? Resolution is defined as solving a problem, creating a plan, and settling a conflict. Yet there has been no problem solved,
Hi,
no
guys.
plan created, and no settlement of this conflict. Instead, TFI Family Service caseworker Sherry Wampler, with the full knowledge and consent of Judge Nicholas St. Peter, has trafficked 3 little girls away from their biological family and has rewarded foster families in their county. This human trafficking of children away from their biological families is not something that has happened once in this county or with this caseworker, Sherry Wampler. Another family has come forward with the same story. This time, 2 siblings have been stolen from their biological family and trafficked to a nice foster family that were friends of Sherry Wampler. Again, TFI Family Services threatened this family and even sent one of the supervisors to the family house to get into a physical altercation with its biological mother. This woman is so terrified that she has gone into hiding. Resolution is an in-depth investigation into TFI Family Services and Cali County court system, focusing on Sherry Wampler and Judge Nicholas St. Peter. Resolution would be Emma, Cora, and Rosa being removed from the Pacellas and returned to the loving arms of their extended biological family. Resolution would be creating pathways for all families to protest the abuse of discretionary power of TFI Family Services or the court system. Resolution is giving the Office of the Child Advocate power to remove children from counties or case teams that are not following the guidelines for placement. Resolution is monetary fines for caseworkers, GAL, CASA workers, or court systems or foster agencies that abuse their discretionary power. Resolution is not allowing attorneys to state in court who cares about the siblings. It is judges, attorneys, CASA workers, GALs working with extended biological families to show that they care about the siblings. Resolution is not DCF caseworker Larissa Lewis's comments in the BIS. You need to make sure that you test these children if they ever want to get married so they don't marry a sibling. Giggle, giggle. Resolution is working with the extended family to make sure that all of the siblings know each other. There are many research studies and case studies that show children have greater success in life when they grow up with their biological families. Resolution is stopping TFI Family Services and other child welfare case management providers from human trafficking. Yes, I said human trafficking these children away from their biological families. Resolution is not targeting poor drug-addicted families or families that have fallen in hard times to take away their children, grandchildren, nieces, nephews, cousins, brothers, and sisters. In 1978, the Indian Child Welfare Act was created to stop the trafficking of Native children away from their families. Kansas children deserve the same protection from being trafficked away from their biological families. That is resolution.
Representative Howerton, before you ask questions, the discussion about siblings this morning, to discuss about the case that we were involved in. It's good to hear that things are being changed. Our case, there were 2 children taken into state's custody that are biological siblings of our adopted children. No notification, none, 0. When we had Emma taken from our home by a purposefully dishonest process, and then we tried to work with the courts for 2 years to go through the BIS, to maintain the visits. And for us, Riley County, Cali County, north to south, opposite ends of the state, 180 miles each direction. We made those trips twice a month, and we had to get a court order because the caseworker from TFI Family Services was willing to ignore or deny the biological relationship when it suited her goal.
Thank you. And your case is kind of closed, correct?
There's
right
a
now?
3rd child that's been taken into custody. We know the name. We know that she was born probably June or July. We know the first name. That is it. There was no notification. The only reason that we know anything about her is biological mother reached out to a sister of hers and said that the child had been taken into custody. We know that it was placed with the foster family. When our caseworker, we were still at our license, was flat out told no, that they were not going to give her any information from TFI Family Services. No grandparent notification, and I know you're big on that one. No grandparent notification, nothing.
So no letter, no
Nope.
phone call?
Nope, nothing.
Nothing. Okay.
And in the process of, after removal of the child that we call Emma, we had to wait several months until the case reached a point where we could ask for sibling visits,
Because they refused.
because they refused. And then we had to get Judge St. Peter to provide the order. But in all honesty, looking at that particular judge, he was only doing the bare minimum to prolong the case so that they could then make a specious bond over blood argument of why that child, after termination of parental rights, could not be returned to her sister Anna and her brother Jamie.
And rights were terminated less than a year after she was removed. And every time we went to court, we asked for her to be placed back with her siblings. And we were told no.
And TFI Family Services and that case team had zero desire to correct any wrong.
Thank you for coming forward. Questions, Representative Humphries?
I just have a quick question. I think some of the issue that we see over and over is there's no reason given. Did they let you know why you were not the chosen, the family that they chosen the BIS? Or, I mean, that seems like something that we do hear over and over. It's just a decision, but no explanation.
So we were allowed to participate in the BIS for the brief portion of our time. The BIS process, which our previous written testimony has discussed, it's wide open. It is not clear of what is in front of the members of the BIS that's being considered. It's not informed to us what is being considered. In the end, it boiled down to that they just went, well, she has been with the foster family longer than she was with you. Well, I'm going to go ahead and say yes, I understand, longer time with them. I held that child while she was dying. First 9 months of her life, I'm her papa. When we were going to visits, I know it caused grief. She called me papa, because that's what I am in her life.
And that's what her siblings call us, Mama.
So we basically, our lawyer was a very good man. And I'm glad we had a good man. He didn't go after people angrily like the lawyers that went after us angrily.
So to answer your question, we did not, all we got was a letter saying we were not chosen for placement.
Yeah.
Okay,
was it.
Thank you. We're going to have to move on, but I do want to remind you that we did get that BIS appeal process changed as of January 1st this year. So
Yeah.
that is a direct result in your advocacy, so I appreciate that.
thank
Yeah, thank you. Okay, next up we have Melissa, is it Busher? Bisher, private citizen. Welcome to committee.
Melissa, go girl.
Thank you,
We got you.
Madam Chair and members of the committee. My name is Melissa Bisher, and these are my children. My children were Kansas residents their entire lives, living primarily with me until they were removed from this state on allegations that were quickly determined to be unsubstantiated. That was 3 years ago. That moment did not begin a custody dispute. It revealed a complete collapse of oversight and due process in our state's family courts. This case began in Pottawatomie County under IVD child support jurisdiction, carrying both state and federal oversight through DCF and the United States Office of Child Support Enforcement. For nearly a decade, the same judge presided. He knew the history, he knew the evidence, and he knew my children. That stability mattered. But when the case transferred to Shawnee County in 2021, that oversight vanished. It was re-registered as a non-IVD trustees case with no notice, no hearing, and no explanation. My children were removed before I ever set foot in that courtroom via email. That's not due process. That is Deprivation of rights under the color of authority. Motions I filed have sat unheard for over 10 months in violation of Supreme Court Rule 170. Orders appeared without pleadings. An agreement was filed with an unauthorized electronic signature. My attorney explicitly declined to approve. Hearings were held with no certified recordings on a Sunday. Orders were signed for hearing dates that do not exist, and transcripts cannot be located. And my children were ordered to a therapist not licensed by the Behavioral Sciences Board. I objected in writing in an open court. The order stood. As a state licensed insurance professional, I'm legally bound to report fraud, yet I was compelled to participate in it. I did not go quiet, you guys. I engaged with DCF, the Office of the Child Advocacy Center, the County Trustee's Office, the ADR, and case management. I submitted evidence, received confirmations, and then watched records altered after submission and dockets that no longer matched what reflects on the record. I've reported over 100 incidences of noncompliance since 2024, as documented to case management. Still, no enforcement, guys. Committee, this is not just my story. Families across Kansas, they're being pushed into poverty through fees, duplicative services. Cases are paralyzed by missing records and agency silos. And parents who report misconduct face retaliation, not relief. Oversight is supposed to protect children, not disappear when it crosses administrative lines or a judge rotates. In my case, the court-appointed guardian ad litem refused to review evidence, disregarded reports from licensed professionals, and filed recommendations that contradicted documented facts. When I challenged these actions, I wasn't protected. I was punished. The very people certifying these ethics programs and certifying their continuing education for the court professionals are the same ones blocking licensed clinicians from submitting evidence. Guys, this is not ethics. This is institutional blindness, and it leaves Kansas families defenseless. Not only is this a family court crisis, this is a civil rights crisis. When hearings go unrecorded, when signatures are falsified, when records are altered, and when oversight agencies look away, the Constitution doesn't stop at the courthouse door. It fails there. I respectfully ask this committee to act, audit all cases removed from IVD to trustees' administration offices, and reconcile the orders and pleadings. Establish an independent oversight board for GALs, ADRs, and case managers with public accountability. Implement immutable audit trails and mandatory audio recordings for every hearing. Protect parents and licensed professionals who report unlicensed practice or record tampering. As I stand here today, my children still lack the court-ordered therapy that could help them heal. Oversight is not retaliation. Oversight is protection. Please open the books, reconcile the records, and give families, Kansas families, a system worthy of our children.
Amen. Go.
Thank you very much. I did attach my case numbers behind this and some information as well, and I'll stand for questions.
Thank you. Committee questions? Okay. Thank you for coming. Thank you for speaking out. This seems to be a pattern, and that's good. Did you have Representative Johnson?
I need help on the, is it IBD?
IVD cases.
IVD. Could you tell me what that is?
Yeah, so when this case started, we were receiving some support through DCF when this case started kind of periodically. And so we were under the umbrella of the IVD cases. So there was some additional oversight for the 10 years that this case was under the Pottawatomie County jurisdiction.
Yeah, the initials, what do they stand for? Do you know?
The IVD, I don't know the actual terminology. I just know that it has some state oversight
I think
because
Tanya
there's some
Keys can get,
funding
Dear
matching that goes with it.
Yeah, Deputy Secretary Keys, would you expand on that?
Yes, please.
Hi, Tanya Keys. IVD is also known as Title 4-D. So Title 4D is, speaks to the federal funded source connection. So it's Roman numerals, IVD. Yes, thank you, Secretary, for child support services.
thank you
Okay,
so much.
4D.
Chair.
Okay, perfect. So you started with, I guess just to clarify, you started with like a family in need of assessment and like some supports, or
When this case started, I was on financial assistance. I had Kansas Legal Services at the inception of the divorce with the children, and so they received some services and things like that. So
Okay, so no formal investigation or anything like that?
there were abuse allegations that my ex did file in Shawnee County, but they were quickly determined unsubstantiated.
Did he file those under his name or anonymously? Do you know for sure that he filed those? I'm just curious. We have another piece of legislation.
He did file them himself. Him and his wife did.
Okay. Okay. Any other questions, committee? Thank you.
Thank
for
you
coming
for
forward.
having me be here today.
Okay,
Appreciate it.
next up is Gib Davis, private citizen.
Go Gib.
Welcome to committee.
Chair and members of the committee, my name is Gib Davis. I'm a Kansas father. I currently am restricted to seeing my daughter one night a week, every other weekend, due to a series of false and unfounded allegations. The issue is not of lost contact. The issue is that the restoration of the full relationship with her has been delayed, not by evidence, but by process, in my case. Therapy supported reunification. That process did not result in expanded parenting time. Instead, positive reports were concealed, and therapy was cut off, in which my parenting time remained limited. My guardian ad litem, Edward Biggis, was appointed to represent my child's best interest, but there has been no clear or timely path to restore parenting time. Despite the process, instead, hearings have been continued repeatedly, decisions have been delayed, and the status has remained in place. So my relationship with my daughter is being shaped by delay, not by evidence. There is also a concern about neutral. At the time of the appointment, the same guardian ad litem, Edward Biggis, was involved in a separate case concerning my immediate family, my brother and nieces. There was no clear disclosure and no review process to address that. In addition, critical information, therapy process, progress, and evidence supporting reunification was not brought forward in a way that allowed the court to fully consider it. It remains concealed. At the same time, I was ordered into private services with significant cost. The result is time. The result is this. My ability to maintain and restore my relationship with my daughter has been impacted not by finding that I'm unsafe, but by financial barriers and lack of transparency. When access to your child depends on the ability to pay for services that cannot clearly regulated, not independently reviewed, and not subject to meaningful oversight, that raises serious concerns. As a parent, I would not be allowed to place my child in care of someone without oversight, licensing, or accountability. Yet in family court, parents often ordered into private services where those same safeguards do not clearly exist. That inconsistency needs to be addressed. When I reviewed the record, I also found conflicting timestamps on court orders, orders entered during transfer without clear jurisdiction, service and notice inconsistencies, and conflicts involving legal professionals that were not disclosed on the record. These are basic safeguards. They are not optional. When they fail or when cases are allowed to stall, parents lose meaningful time with their children, and that time cannot be given back. Right now, there is no independent oversight of guardian ad litems,
You have 1 minute.
no enforcement. So I'm asking Pacific Action, independent oversight of GLL's appointed professionals, required conflict of interest disclosures, and review process, enforcement of neutral standards and family law appointments, limits on repeated continuancies without good cause, direct submission of therapy reports and rentification programs to the court, protection against financial barriers that interfere with parent and child relationships. This is not just my case. We are seeing the same patterns across others. This is systematic, and the cost is time between parents and children that can never be restored. Thank you.
Thank you for being here. Questions, committee?
Good job, Bob.
So do you have an attorney, or are you representing yourself?
I have an attorney, ma'am.
Okay.
Yeah.
Representative Humphries?
Yeah, and just what county are you in, or what is
I
court,
am in,
the court district? Yeah.
I apologize, Miami County, Kansas, case number MI-2024-DM-000031.
Okay, thank you.
Okay. Thank you for being here. Thank you for speaking out.
Hey, thank you.
Yep. Next, we have Karen Ross, private citizen. Welcome to committee.
Thank you. Chair Howerton, Vice Chair Gossage, Ranking Minority Member Owsley, and members of the committee. My name is Karen Ross, and I'm a high school counselor in Kansas with 30 years of experience in education. I'm also a mandated reporter. I believe in protecting children. I believe professionals should report suspected abuse when required by law. And I am here today because I have seen what happens after a report is made and where the system breaks down. In Kansas, we have built a system with strong pressure to report and react, but far weaker mechanisms to correct errors, notify parents of their rights, or restore normal family involvement when allegations are not substantiated. That imbalance does not stay contained within DCF. It spreads into schools, hospitals, and other institutions, and children feel the effects immediately. Children experience fear and instability when systems escalate without resolution. Stability, parent involvement, and consistent relationships are critical to their well-being and educational success. My family experienced that directly. My stepdaughter was encouraged to make a false allegation against her father. The investigation remained open for months despite no findings. My husband was not informed until after law enforcement became involved. Even after the claim lacked support, the case remained open. No meaningful reintegration ever occurred, and we have not had a relationship with her in 3 years. This is not an isolated issue. Kansas data shows most child protective reports are ultimately unsubstantiated. Reporting must continue, but there must be meaningful process to correct the record when allegations are not supported. Right now, there is not. Instead, a report triggers a chain reaction across multiple systems. When the allegation is unsubstantiated, there is often no correct corresponding mechanism to stop the chain reaction. That is where the real harm occurs to both children and families. Since submitting my intent to testify today, we discovered something deeply concerning. A raw DCF intake report before screening or investigation was placed in both my stepchildren's permanent school records. It identified my husband as a perpetrator and included detailed allegations, names, and contact information, including the reporter's contact information. This is not a finding. It was not substantiated. It was simply just the initial report. Yet it remains there in their permanent school records as if it were fact. This raises serious questions. How was that shared? Who authorized it? And how often is this happening to other families? My requests to this committee are straightforward. First, clear written parent right notifications when an investigation begins, when an institution relies on child welfare related restriction. Second, require a school, hospital, or provider that restricts a parent's access to identify the exact legal authority, whether it's court-ordered, statute, or agency directive. If no authority can be cited, the restriction should not occur. Third, require a written closing summary and a functional correction process when allegations are unsubstantiated, so false or incomplete information does not continue to follow the family. Fourth, require a lost parenting time returned. When a parent loses court-ordered time because a child protection investigation that does not result in abuse or neglect. For example, Texas Family Code 157.168 provides this useful model. I do believe Oklahoma is also using this. Kansas should require equivalent makeup time for the same type and duration of parenting time that was lost, including weeks, holidays, and summer possessions, so unsubstantiated allegations do not still accomplish the goal of cutting off a parent from a child. Finally, track repeated patterns of unsubstantiated reporting and their downstream impact, so misuse of the system can be identified and addressed. These are not abstract policy ideas. They are directly affect whether children experience stability or prolonged disruption. Children need protection, but they also need accuracy, they need stability, they need lawful process, and they need institutions to stop treating unverified allegations as if they were proven fact. And I want to thank the committee for your time allowing me to speak here, and I know that there's been work done to this. I know several of you have worked with us, and we really appreciate that.
Thank you very much. Committee questions? Representative Humphreys.
Go Humphreys. We love Humphreys.
So just a little background I think would be
Mayor,
helpful if you don't mind, but it's you don't have to answer any of this if you don't want to. So how old, so this is your daughter?
My
I'm assuming-
stepdaughter.
It's your stepdaughter and you're married to her father?
Yes, ma'am.
Okay, and how old was she when the allegations were made?
She was 15.
Okay.
She's now 18, so
Yeah.
there's nothing we can do with
And
that.
so, and you know who made the, I mean, she herself made the allegations, but I think you said she was encouraged to make allegations.
Yes, we've been investigated over 15 times, police calls, all kinds of false allegations over the years from the other parent. It was encouraging parental alienation,
That's what I was
honestly.
wondering. Okay. Sorry for your situation. Thank you for coming to the committee.
Thank you, ma'am.
But it ended up in school records. That's what I'm really trying to understand. This is the first I've heard of this.
What
So
alarmed me was it was the exact screenshot. So I've had to make hundreds over the years in my career. It was the exact screenshots from when I go to a DCF website and begin to make a report. It was each page before, it's what it looks like before it's submitted. How that got printed off and sent to a school because it was from a hospital.
it was from a hospital?
Yes, ma'am. A social worker at St. John's Hospital made this report, and then somehow it's in the children's permanent school records.
Do you know of this happening to other children?
I don't know. I've never seen that. That would, as a reporter, that would frighten me. I've had parents come and scream at me. So, I mean, if they had my home address and personal number and all this information you put in there, that's not okay.
Okay. Senator Erickson.
Thank you, Madam Chair. Following up on that, Did the school act on that information? Did they prohibit your husband from attending school functions, or did they act on that?
Yes, there was, and honestly, and as an educator, the restrictions are kind of gray. We don't know.
Okay, so I hope you all can hear me, but I wanted to just mute this for a little bit to kind of tell you what's going on. So if you filled out the admin, and please share this and heart it, I'm doing this for free. I don't get paid to do this. I get nothing. I'm pretty broke, but I'm getting everybody's data for you guys so you can do this too at your state. Okay. Can you hear me okay? Everyone good? Can we see some thumbs up, please? I know it's going to be delayed. And after this, I'm going to show you the updated family rights survey. I'm froze. Am I froze? Let's hope not. Anyway, okay, thanks, Taylor. I'm going to share what this registry, the survey, has done and built. As of now, I think we have 30 states out of 50 that can download the report. What do you do with the report? I'm going to show you what I did with my report in Kansas, and I'm going to show you how not to do that. No, not on Facebook. Can you hear me talking, Taylor? Okay, Melissa, you can hear me. Okay. I'm going to turn unmuted again. I just wanted to tell you guys, this is what you're experiencing today is what we are doing, what you need to be doing in your state. And that's why I'm trying to create data for every state so that you can take it. Thank you, Sarah. So we have another person talking, and then I will back up. So if you know, Taylor spoke today. She was the one that I posted about a few days ago. She spoke. She has a ton of followers on our social media platforms, and she's in Kansas. And let me go see what this woman is, and I don't want to cut anyone off, but I also don't want to bore anybody. So let me go see what this one is.
Really was in Texas. I live in North Carolina, and the case originated in Virginia. But the evaluator in my case was Dr. Milford Buddale of Topeka, Kansas.
Buddale.
He holds both a PhD and a JD law degree.
He actually works
and presents as a highly credentialed expert. However, the substance of his evaluation raised serious concerns in my case.
Yeah.
He was appointed to conduct a psychological custody evaluation, but instead, over a period of approximately 30 months, about 94% of our interviews focused on reviewing legal filings, not evaluating the children present day, not assessing their current parenting environments, and not examining the present day conditions affecting their well-being. These legal materials were 8 to 10 years old at the time he was evaluating them. They had been already adjudicated from a state where no party lived at that time. Yet the evaluator repeatedly interpreted legal matters across multiple jurisdictions where he's not licensed to practice law and never has been licensed to practice law. At the same time, the evaluation lacked basic hallmarks of professional methodology. There were no standards of psychological testing, no defined evidence-based assessment tools, no process to identify or mitigate biases. Over the 2.5 years that we did this, there were no meaningful assessment of the children's current lives or my home environment that precipitated it. My children are now 16 and 18 years old. There was also serious procedural and professional concerns. The evaluator was unresponsive for over 8 months. He reappeared only after a motion to compel in Texas in Dallas court. And he had not obtained key records even at that time, even while claiming the report was ready to go.
Okay, I want to address some questions I see some going on. So Carrie Cameron on Facebook, you can do it Zoom, okay? You don't have to travel. You can submit your story. You can submit my state stats that I got for everybody. On the Instagram side, somebody said they wish they could do this in Massachusetts. You can. I have your data. Let's go see how many Massachusetts people have submitted their story. Let me go there now. Hold on, let me pull it up on my computer. So this is what I'm trying to get people to understand. When you tell your legislators that this is not just one story, it's systematic, meaning it's happening all over your state, all over the globally, all over the world, but your state capital is the ones that would have to address that. Okay, let's see what Massachusetts is right now. How many do we have in Massachusetts? We have 33 submissions. So Massachusetts, we already have your data sent out. If you go to my website, standwithmeg.com, and you can go click the button that says get your state report, you will automatically get a link to download it. If your state was in Nevada, you fill out the Nevada, even though you live in Virginia. Okay. So there's some questions there. Speak safe. Good. Yeah, we probably need to do that. So we have it all in one. Have you, Speak Safe, have you downloaded the California data and maybe compared it with yours? So you know what, as of right now, let me see who else is speaking. Hold on, I'm going to show you guys a way to look all this up. Well, we can go look at it. Here, let me pull up Massachusetts. Who else is here from Massachusetts? Anybody here from Massachusetts? Let me go pull up my Instagram. Sorry, it's everywhere. No problem, Rosie. I'm in Massachusetts, experienced this. Okay, Allison, have you filled out my survey? Let's go look at your stats. You can have the ability to, help us in Kentucky. I have a Kentucky too. So first off, let's go see what I submitted with my report. So everybody's getting a report. Once your state hits 30 submissions, your report will be generated where you can go and request for it to be downloaded. Now that link I put on for you to get, it's going to update. So today, everyone that has that link for their state, it updates the new one. Does that make sense? So if that doesn't make sense, let me know. Oh, Megan, there's so many Megans nowadays. So when you have your report, let's go look at, and then I want to go and I want to show you guys what Taylor did, her speech today. She did awesome. No, I don't want to do that. How do I change the screen I want to show? I don't know. I haven't done this. Replace. Okay, we are going to do this. Got it. Share. Okay, so right here is my state, West Virginia. How many? Let me go see West Virginia. I'm ADD all over the place. Blah, blah, blah. Let's see. West Virginia, you have, I thought you were pretty high up. I remember. I'm blind. Hold on. You have 32. So you already have a report out there. Amy, did you get your report? Let's see what Kentucky has. Kentucky has 45. You guys got 45. So you already have a report as well. So this is what you do with your report. How again do we find the link? Please go to standwithmeg.com. Here, let me put that on my I need to put that on. I don't have time right now, but I need to put that on my thing. Everyone needs to go to standwithmeg.com. There's two buttons right when you go there. One of them, it says Add Mine Family Court Survey. So that's the button you're going to click to go fill out the survey. Then after that, you can also, the other button is what's your report in your state. You click what state you're in, and it's automatically going to email you the link for you to download. And then what you're going to do is you're going to use this for speeches. You're going to share it with your legislators, teach your legislators. So for instance, here's everyone that spoke today. Okay. This is all their testimonies. Now I couldn't speak. I'm going to speak next time. But look, Megan Miller, here is my speech that I wrote to submit. Even though I wasn't there, you can still write written testimony. It's called written testimony. Here's what I wrote about my situation. And then guess what I did? I added Kansas's report. Does that make sense? And this is what I want you guys to do, because then if you look down, I break it down. So any other, I'm trying to see if there's any questions. I'll just all by myself. But this is what I'm trying to teach people on how to do. So hold on, let's see if I can. Does that help the screen? Not really. But this is what you do. You send this and show anyone, the news, as it gets bigger and bigger. California's gotten pretty big. So like, for instance, this tells me what counties are really highly affected. Oh, I missed the counties. Anyway, it's slow because it's such a big thing. But yes, this is how you fill it out. So let me just go to my website so everyone can see. Okay, right there. You see it? You see the buttons, people? Those are the buttons. So you click here to, well, I don't want to go that high up. I don't like to see my face, but you click the left, this button, all the way up there, see it? You click that to go fill out your information, and it can be anonymous. And then you click the other one if you want to know your data for your state. And then you're going to get a link. So, yeah. That's how you do it. Good. Thank you, Allison. That means a lot. I'm going to pull this down just a tad. I don't like how far up it is. There we go. So we have add mine, get your state report. Add mine, get your state report. So sharing this, stars would be great, but I'm going to back up. Let's go see what the committee's doing now. Megan, ooh, this is a good one. Love Megan. There's her kids.
Fully participate in, and later I discovered may not have been neutral. For more than 12 years, I was my child's primary custodial parent. My child lived in a stable home, attended schools consistently, and maintained longstanding relationships under court-approved parenting orders. There were no emergency safety findings requiring removal. What changed was not my parenting. What changed was the process. My case was ordered into domestic conciliation, a process that parents are told relies on a neutral third party to assist the court in resolving custody disputes. At the time, conciliation services were already in place through court services. However, approximately 85 days after opposing counsel, Brian Frost, entered his appearance into the case, a motion was filed requesting that the existing conciliator be replaced. That motion specifically asked the court to appoint William F. Ebert III as the new domestic conciliator. What I later discovered, almost 3 years later, through public court records was deeply concerning. Prior to that request, and continuing throughout the duration of the conciliation appointment, Mr. Ebert was actively serving as personal counsel for the opposing counsel, Brian Frost, in his own Shawnee County family law domestic matter. In other words, the attorney representing the opposing party in my custody case requested that the courts appoint his own acting personal attorney to serve as the neutral conciliator overseeing decisions affecting my child. This professional relationship was never disclosed to me before the appointment. I did not knowingly waive that conflict, and I could not give informed consent. And I had no reason to investigate the neutrality of someone presented to the court as independent and professional. At the same time, I was receiving state assistance through DCF. I repeatedly informed the court-appointed professionals that I could not afford privately billed conciliation services. Despite this, the privately paid process moved forward. Because I could not pay the ongoing fees, I was effectively unable to meaningfully participate for several years in proceedings that generated recommendations relied upon by the court. Reports continued, recommendations continued, and court reliance continued, but my participation was not allowed to continue. My financial status became a barrier to being heard in decisions determining my child's stability. After filing my motion, I continued reviewing publicly available cases and discovered multiple unrelated custody matters reflecting similar professional overlap patterns involving the same conciliator. This raised concerns that what occurred in my case may not have been an isolated incident. This concern is amplified by the fact that the conciliator involved has held leadership roles influencing family law standards and professional guidance within the Kansas legal community. This leads to a simple policy question for this committee. If a litigant's attorney can request appointment of his own professional associate or attorney as a court-appointed neutral, and parents lacking financial resources cannot meaningfully participate in that process, what safeguards currently exist to protect public confidence in custody decisions in Kansas? Family court decisions determine where children live, who they see, and how families function for years to come. Yet neutrality screening, conflict disclosure, and indigent participation protections remain inconsistent. I am not asking this committee to decide my custody case today. I am asking whether Kansas families should have stronger statutory protections ensuring that court-appointed neutrals are independent and accessible to all participants, regardless of income or representation. Because children should never experience instability created by procedural gaps rather than demonstrated parental harm. For 12 years, my child's stability was never questioned. What changed was access to participation, access to neutrality, and access to justice. Before I finish, I would like to encourage you guys to read the testimonies of those that did not speak today, as they are filled with stories very similar to mine, and the data is actually quite alarming. Thank you for your time and commitment to Kansas families. I will now stand for questions if necessary.
Good job, Megan.
Committee questions. Did any of you participate in the judicial informational hearing, the committee?
Yes.
You guys did?
We did.
Okay, perfect. Any other questions? Okay.
Thank you.
Thank you for being here. Okay, I will direct committee to written testimony from Gil Kozad, from Chief Executive Officer of Kansas Children's Servants League, Sherry Lesher, private citizen, and Kathy Winters, private citizen. And now we're going to start.
There's more.
And Sarah Goebel, private citizen, and Megan Miller, private citizen. Thank you.
There you go. Good job.
Now we're going to move to the Office of the Child Advocate, Carrie Larnard, for her update.
Okay, so now I'm going to back up so we can rewatch.
Thank you very much, Carrie. Welcome to committee. Welcome back to committee.
Taylor. So let's back up to her, okay?
Thank you, Madam Chair. Good morning, members of the committee. I'm Carrie Larnard, Office of the Child Advocate.
So this what's neat about it, you can always back up and watch your speech and record it and post it. But I'm going to back up to Taylor because I missed hers. Yeah, here she is. So this mama, I shared her story last week. She's pretty big on her social media.
Understand,
let's watch
it's
her.
not out of malice, it's out of good intention so we can hear everyone speak. You can reach out to any member on the committee to follow up with your situation. I'm willing to talk to you and follow up with you at any time. So with that, we'll start this time. I'm going to give you 5 minutes, and then we'll have probably a couple minutes for questions. So we'll start with Taylor Arkland, private citizen.
Let's go, Taylor. This is her first time speaking.
My name is, thank you. My name is Taylor Arkland, formerly Taylor Renier. That's relevant because if you want to look up my case details, which I encourage you to do so, that's what it will be under. 22 days ago, I honestly never thought I would be standing here today. I have 5 children. 4 of them I share with my ex-husband. My youngest, my 1-year-old baby boy, he is with my current husband now. So 22 days ago, my children, my older 4, lost all contact with not only me, their mother, but also their baby brother. And it was not an accident. It was court-ordered. 22 days ago, my children had both of their parents actively in their lives. They had stability, they had routine, they had consistency, and they had their mom every single day. I had 50-50 custody with my ex-husband prior to 22 days ago, and on his weeks with them, we would always FaceTime, and we're always in constant communication, if not in person. So my children really had never gone a single day prior to them even being born without me in their lives. So, in less than 24 hours, everything changed. They went from having a present, involved mother to only being allowed to see me under supervised visitation, which takes a little bit of time to get set up. If you guys don't know, I found that out the hard way. So, I've yet to still talk to my children as of today.
Same.
So, I've never stepped foot in a Shawnee County courtroom a single time through my divorce, through my custody proceedings. I've never had a hearing. In my case, there's no findings of abuse. There's no findings of neglect. I have no substance abuse history or issues, and there's not even accusations of such. There's no past or present DCF cases that have ever been opened on me for any of my kids who are around mandated reporters every day. They go to a public elementary school, they've been to daycare their whole lives, and I've never had anyone raise concerns about my ability to parent my children. So, and yet my children still lost the normal everyday presence of their mother. And really, this is the harm because my kids don't understand legal processes. They understand loss. And what they feel right now is that their mom was there and now she's gone. In my case, we had to go through a process of conciliation. And when I asked the ADR professional if I could review and verify the information that was being used about me to make recommendations to the court about our custody situation, I was flat out denied because I was pro se, was his words. And after I raised those concerns, I faced further retaliation that further limited access to my children. The court docket does not show actually that any conciliator report was ever even filed properly. So there was nothing available for me to even challenge or object to because no report was ever filed or formally provided to the courts. So the date is ambiguous, and it's a 30-day period that you're allowed to file an objection, but there's no filing. So that and the limited information that I was able to receive regarding the recommendations, I received a one-page, these are the recommendations. I did not receive the full report that stated the reasoning behind the recommendations at all.
Same with me. Same thing.
And this is what happens. Parents are being punished into poverty. I'm looking at spending over $1,000 a month just to see my children under supervised visitation. And it forces instability onto children.
Yeah.
Also, we all know
story,
it's 2026. We live in a world where AI can literally create or manipulate evidence in seconds.
Yep.
When I asked the conciliator and shared my concerns about evidence, I was not able to review any of the evidence that was submitted by my ex-husband. So I don't even know if the evidence is real or accurate at this point. So, private court-ordered services influence children's lives, and without clear oversight, there is risk. The children are the ones who are living with the consequences. They're the ones who lose stability, security, and relationships with parents they love, who have been primary caregivers their entire lives. And what I've learned over the past 22 days in Kansas is terrifying because it could literally happen to anyone who has not the best co-parenting relationship with their ex. Let's just say that. So that's why I'm here today, because there has to be checks and balances, because when these ADR professionals are given so much authority over children's lives, there has to be accountability, there has to be oversight, and there has to be clear processes and laws that are actually followed. So, yeah, that's all I have today. Thank you.
Thank you very much. Committee, we'll do questions real quick.
Yes.
Do you have questions? Representative Humphreys.
And what county or what district court are you in?
Shawnee.
And what about your due process rights?
I actually filed a motion as of Friday, and it just got entered this morning. I saw on the docket asking the court to vacate that order because the due process in several instances in my case were not followed. So I have yet to hear a
We'll be anxious to hear how that goes.
Yeah.
Thank you
Yeah,
for
I
coming.
did that. It didn't work.
Thank you. Any other questions? Senator Erickson.
Thank you, Madam Chair. Thank you for being here.
Yes.
Just a quick question. You said it's costing you $1,000 a month for visitation?
Yeah.
Why?
So a lot of the times the recommended provider charges almost double of what other court supervisors charge, but unfortunately this is the provider that courts are recommending, and most of the time my ex-husband's attorney actually, I tried to use other supervisors that were more cost efficient, but my ex-husband's attorney filed a motion to enforce me having to use this particular provider that's $70 an hour per supervised visit with a minimum of 2 hours. So I was calculating it last night, and 6 hours of parenting time per week to see my children would be over like $1,600 a month.
Is there any way to recoup any of that cost?
No, I'm responsible for all the costs.
Thank you. Thank you, Madam Chair.
Senator Falscudo online.
Thank you, Madam Chair. This particular situation has come up. I've been contacted by a constituent, and if somebody in the room could answer this question or clarify. So what my understanding is that if you are dealing with a divorce case and you've got 50-50 shared parenting, that the courts for divorce and children issues, they do pay for that supervised visitation, but you don't pay that if your children were removed for abuse and neglect and they are in state custody. So I think we really need to get a better understanding and make that a distinction on this particular issue. So I don't know if anybody can address that or not, but I think it might be helpful. Thank you so much, Madam Chair.
So just to clarify, this is not a DCF custody issue. This is a divorce custody issue.
Correct, yes.
Okay. And these stories have been coming up. It's really not the purview of this committee to cover family courts, but Representative Humphreys is chair of judiciary, and she actually had a hearing on that very thing this session. So do you want to say something, Representative Humphreys?
Oh, just said, we had an informational hearing in March on child custody and child support, and it was heartbreaking, the stories that we heard. So the informational hearing, it doesn't result in any necessarily any legislation, but it gave the committee a good taste of what a lot of us are hearing on this committee. So the Judiciary Committee, separate purview. And so, we will certainly be considering it as far as what we can do as legislation. But hopefully others can advocate for you and others like you. So.
Thank you. I
You're
appreciate
welcome.
that.
Thank you.
Thank you, Madam Chair.
Go ahead, Senator Falscudo.
Well, I was just saying thank you. That answered my question. Thank you.
Okay, thank you very much for being here. So next up, we have Peter and Kim.
All righty. I'm going to end this so I can start working on the states. So if you have not filled out your Add Mine Family Rights Survey, please do so. Let me go see how close we are. Oregon just passed over, so I actually just got Oregon done, and you guys can go and request Oregon to get that report. I know New Jersey was close, but we need to go do that. And Christy, I would love that, but no one's touching my judge, but he's the chair. Anyway, so I'm going to go, and thank you for letting me get ready here on. I'm going to repost some of these speeches. Go to your legislators, take your report, go start telling people and exposing people what's going on in our family courts and CPS. So have a great day. Stand with Meg. Bye-bye.